Does every single person that is affected by this EO have to bring their own suit? Are there alternatives? How long does it take?
The fact that courts back in English Chancery couldn't enjoin the king, I think, is not analogous or indicative of what courts can do in our system, where the king, quote unquote, the executive, is supposed to be bound by the law.
Your theory here is arguing that Article 3 and principles of equity both prohibit federal courts from issuing universal injunctions. Do I have your argument correct?
We argue both of those. And
you argue both of those?
Yeah.
If that's true, that means even the Supreme Court doesn't have that power.
The Supreme Court would have the authority to issue binding precedent nationwide.
All right, we've got this fiery debate in the Supreme Court over birthright citizenship and the power of the lower court judges. The justices peppering the Solicitor General there with some tough questions for more than 2 hours as the High Court considers nationwide injunctions. Should lower courts be allowed to block presidential policies across the country? On day one of his second term, President Trump signed an executive order that would limit birthright citizenship to those who have at least one parent with citizenship or permanent legal status. But the 14th Amendment of the Constitution says that all persons born in the United States are citizens of the United States. While much attention is on the order itself, the Supreme Court isn't considering whether or not that's constitutional, at least not yet. The focus right now is, can a lower court judge issue a blanket ruling to essentially stop President Trump? Not just from that order, but from any order. The justices seem more divided on that.
So when the court has considered and addressed this, it has consistently said you have to limit the remedy to the plaintiffs who are appearing in court and complaining of that remedy.
So we survived until the 1960s without universal injunctions.
That's exactly correct. And in fact, those are very limited, very rare, even in the 1960s. It really exploded in 2007.
Joining us now, Michael Wilds, managing partner with the leading immigration law firm of Wilds and Weinberg, PC. He's also the author of Safe Haven in America, Battles to Open the Golden Door, and he was the immigration attorney for Melania Trump and her family. Welcome back. It's nice to see you, Michael. This boils down to presidential authority, right? The president's power, first off.
Well, also understand this. This is a cherished part of America's identity. We are a jus locale as opposed to a jus sanguine, which means a person can be born physically and become a citizen. We had a very important case years ago. My late father started our firm in 1960, where a child was born on an airplane, an American flag plane, over U.S. territory. And when the plane landed, the mom had to leave within 90 days, but the child was a citizen. You can't sponsor a parent until you're 21 years old. So there's nobody crossing the Rio Grande to have what's considered to be an anchor baby so they can come here 21 years later. The law is working fabulously. In fact, 33 other countries have birthright citizenship, including our neighbors, Canada and Mexico. In this instance, 3 federal judges blocked President Trump's executive order, and the Supreme Court is dealing, as you artfully articulated, with the ruling about universal injunctions. Can these 3 judges universally enjoin the president's executive orders or not? And the thesis ultimately, I'm sorry, yes?
No, that's okay. I was just going to say that conservatives question, though, the need for national or universal injunctions. And you heard Justice Thomas there say that we survived until the 1960s without them. So even before you get to the discussion about birthright citizenship, it comes down to presidential power. Does he have a point there, or does it matter who's in office?
Well, the thesis here is that the Department of Justice can't pick rulings based on their political preferences. Historically, a circuit court's ruling, that is, the district courts in the different circuits in the federal system, are deemed to be binding if in that circuit, unless it's stayed or overturned by that circuit or the Supreme Court. And Justice Barrett here, a Trump appointee, a very conservative, questions that were asked reflected the notion of the separation of powers and the executive's respect for the judicial authority. She by her question shows that there is a co-equal branch of government. And that's really what's at play right now. The president cannot come in and with a stroke of a pen change the Constitution. You know what it would take? It would take 2/3 of the House and the Senate and 3/4 of our nation's legislatures in order to overturn this law. So you have a procedural kind of theater of challenge right now, but it all surrounds something that has been sanctified in an amendment to the Constitution, that if you're physically born in America, you are a citizen, unless you're not subject to the jurisdiction, which has to do with foreign diplomats that have children on U.S. soil and otherwise. Our founding fathers and our documents envisioned a world of freedom from tyranny, and that we wouldn't create differences in our own land based on political preference, or allow a president to choose which laws he would want to obey or change. That is the job of Congress, to make the law, the president to enforce it, and for the courts to evaluate its constitutionality.
Right. Understanding the system in place and authority granted to each of those powers. The constitutionality of the 14th Amendment, one thing the court is essentially taking up here, in addition to the national injunctions, it seems as though Sotomayor wants the court to take up the 14th Amendment and birthright citizenship. I guess the question now, Michael, is what happens now? What's the next step logistically in this process?
Well, that's what's happening. That's coming to a theater near us, no matter how we see it. This president will pick laws that he likes and those that he doesn't. And ultimately, we have the courts to protect the integrity of the Constitution and our system of laws. So I think this procedural argument will play itself out. And if it disposes of it based on the notion of universal injunctions, then it may not have to hear the 14th Amendment. Again, I teach in Cardozo Law School for 15 years, and my dad before me for 33 years. This is coveted law. Notions such as a birthright citizenship, family reunification, remind us of that hallowed journey that immigrants came to this country, how we founded ourselves, and how we continue to endure in the years to come. The greatest risk takers and entrepreneurs are foreign nationals, and we can't afford to make a mistake. A lot of the people right now are counting on us exercising better judgment, not just coming to the middle, but being smart and showing our children that the Constitution is the skeleton, that we add new flesh, and we must respect the laws.
Thank you for your perspective. This is much more than a legal question. I understand it is to you as well a very personal issue. Michael Wilds, thanks for your time.
Pleasure.